The day my son was murdered, my entire world crumbled, and I'm still trying to piece it back together.
You don't get any cool points for shooting women and children.
Stabbed in the face, stabbed in his kind blue eyes that could see things most can't see.
A sweet 16 birthday party in Douglasville, Georgia, turned into a heartbreaking tragedy when fire erupted, claiming the lives of Ajanai Hill and Samuel Moon. Several others were injured in the chaos, leaving the community reeling. The shootings were later linked to gang-related tensions, with the victims being unintended targets. Investigations revealed that the violence was sparked by a social media post involving a gang member's death. Members of a gang known as DBG attended the party seeking revenge, and what started as a dispute quickly escalated into a fatal shooting spree. Shots rang out, injuring 8 others, including Jeremiah Johnson, who was struck and endured a painful recovery.
Laying on that ground, the dirt, from your chest, the pain of being in the hospital.
3 men, 20-year-old Timothy Coleman, 18-year-old Kingston Cotman, and 23-year-old Tackle Beverly Smart were later convicted for their involvement in the shootings. Although the jury did not convict them of murder, they were found guilty of gang activity and aggravated assault. Their actions directly contributed to the deaths of the 1 boy, 1 girl, and injuries to several others at the party. The mothers of Samuel expressed frustration over no murder charges.
There was no one responsible for murdering Samuel. After 2.5 weeks and 20 months, how is nobody guilty?
During the sentencing, one of the family members condemned the actions of the defendants, calling them cowards, and emphasized the senselessness of their crimes.
Aren't men, y'all are cowards. Y'all think y'all hard, y'all think y'all thugs, y'all think y'all gangsters because you picked up that's easy. You don't get any cool points for shooting women and children.
In November 2024, Coleman and Cotman received 320 years each after being convicted of aggravated assault, gang activity, and weapons offenses. Smart was sentenced to 20 years. In the months following the tragedy, multiple individuals also faced charges for their roles in the incident. Michael Williams accepted a plea deal, admitting to felony murder and gang-related charges. He was sentenced to life in prison with the possibility of parole after 30 years. Noah Bradley also pleaded guilty to aggravated assault and received a 20-year sentence, with 5 years to be served in prison. Twin brothers Chase and Chance McDowell were sentenced to probation after serving 12 months in confinement.
Some 320 years, I'm definitely satisfied with them.
Although the lengthy legal process caused frustration, the sentences brought a sense of justice to the families. As one family member said, "Delay is not denial." In January 2018, Blaze Bernstein, a 19-year-old University of Pennsylvania student, disappeared after meeting Samuel Woodward, a former high school classmate in Lake Forest, California. A week later, Blaze's body was discovered in a shallow grave in Borrego Park. He had been fatally stabbed, a crime that shocked the community and devastated his family. Investigations revealed disturbing details about the case. Prosecutors presented evidence showing that Woodward harbored deep-seated anti-LGBTQ+ and anti-Semitic views. He had actively searched dating apps to find someone who was Jewish and LGBTQ with the intent to harm them. Woodward's connection to neo-Nazi groups and extremist ideologies further underscored the hate-driven nature of the crime. Prosecutors classified the killing as a hate crime, and the jury agreed.
Let's be clear, this was a hate crime.
Blaze was an aspiring writer and Ivy League student who had returned home to Southern California for winter break. His family described him as a kind and talented young man who brought light and inspiration to those around him. During the trial, Blaze's mother delivered a powerful and emotional statement in court, recalling her son's warmth and creativity.
Stabbed in the face, stabbed in his kind blue eyes that could see things most can't see, stabbed in his warm hands that penned beautiful poems and stories, held my hand as a boy, and created so many wonderful things.
Blaze's father addressed those harboring prejudice, urging them to find understanding and compassion.
There is no place for hate in this world. And if you're someone out there that is resentful of another race or preference, there's got to be another way for you to be able to find some love or some way to embrace people who are different than you.
In July 2024, an Orange County jury convicted Woodward of first-degree murder with a hate crime enhancement. During sentencing in November 2024, the proceedings were marked by disruption as Woodward refused to leave his jail cell. Despite the delay, the judge ordered the sentencing to proceed, stating that the Bernstein family had endured enough pain. Woodward was sentenced to life in prison without the possibility of parole. Though the life sentence ensures that Woodward will spend the rest of his days behind bars, it cannot erase the grief of losing Blaze. The trial of Dixie Denise Villa, a babysitter accused of manslaughter in the death of Abigail Lobish, has brought renewed focus to the responsibilities of caregivers and the dangers of unsafe practices. Villa was found guilty of manslaughter in connection to the 2019 incident at her residence on the Aliamanu Military Reservation in Hawaii.
She had to take care of 4 small children all by herself. So she gave the slightly older ones iPads to watch them all night, and she gave Abby the fatal dose of to make her sleep. Except for Abby, there was no waking up from this sleep.
Prosecutors allege that Villa, overwhelmed while caring for other 4 overnight, administered a fatal dose of diphenhydramine, the active ingredient in Benadryl, to pacify Abigail and make her sleep. They claimed Villa occupied the others with iPads and resorted to medication for the infant. An autopsy revealed that Abigail had nearly twice the lethal amount of diphenhydramine in her system, which prosecutors argued directly caused her death. While no one directly witnessed Villa giving the medication, the prosecution maintained she was the only adult present at the time.
Throughout this trial, you will hear me ask several witnesses, tell us how Abigail Lobish died. We found no evidence of how many doses were given. We found no evidence of who gave it. And therefore, I cannot tell you what happened.
The defense contested these claims, arguing that there was no conclusive evidence linking Villa to the administration of the drug. They suggested that others, including the girl's parents, could have been responsible. They also highlighted the lack of clarity on how many doses were given or when they were administered. After numerous delays in the trial due to the pandemic and witness availability, the case finally moved forward. The jury deliberated and ultimately convicted Villa of manslaughter. Following the verdict, she was immediately taken into custody, and her bail was set at $500,000. Villa's attorney announced plans to file a motion for a mistrial, citing the emergence of potential new evidence involving testimony from Abigail's mother. Villa's sentencing is scheduled for February 26, 2025. She faces a maximum sentence of 20 years in prison. The tragic death of 18-year-old Haiheo Colonna during a botched robbery on Round Top Drive in 2022 left families and the community devastated. In the courtroom, emotions ran high as Nainoa Damon, the son of Honolulu police sergeant, faced sentencing for second-degree murder. Blake Colonna, the victim's father, held his son's urn as he delivered a heart-wrenching statement about the profound loss of his son.
This is what it is, and I carry him. I'm so proud of him. Was trying to protect the little guy.
My son was my entire world, the mother of victim said, describing his ongoing struggle to cope with the tragedy and piece his life back together.
The day my son was murdered, my entire world crumbled, and I'm still trying to piece it back together.
Damon, who was 19 at the time of the crime, addressed the Colonna family directly, expressing remorse for his actions. I humbly ask, I sincerely ask for mercy, he said, acknowledging the pain he had caused. Judge Shanlin Park urged both families to channel their grief into efforts to prevent future violence in their communities.
I ask all of you that as part of your healing, that you will do everything in your power to keep these tragedies from happening again.
After hearing statements from both sides, Judge Park considered Damon's age at the time of the crime and his lack of prior adult criminal record. She sentenced him to life in prison with the possibility of parole after serving a mandatory minimum of 15 years. Damon also received credit for time served, and his other charges, including firearm offenses and robbery, will run concurrently.
Man, when he killed my son, and he got 15 years. Minimum. Oh, my son, follow. I got it. Take him, go arrest him. I got it.
but you gotta calm down. We got court going on.
I was disappointed given the gravity of the impact that this case had on all those that were involved.
While Damon's family quietly left the courtroom, Kelowna's father voiced frustration over the perceived leniency of the sentence. Joel Rondon, a Lakeland father, faced sentencing for the manslaughter of his daughter, Isabella, who tragically died after being left in a hot car. The incident occurred after a 4th of July celebration in 2023, when Joel and his wife, Jasmine, returned home late at night with Isabella and her 2 siblings. While Jasmine took their older ones inside, she instructed Joel to bring Isabella in as well. However, Joel mistakenly assumed Jasmine had already brought her inside and went to bed without verifying her whereabouts.
He was instructed to get the victim out of the car, and when he came back after taking food items inside of the house, he saw that the door was allegedly shut, so he thought that the victim had been taken inside.
The next morning, around 11 a.m., Joel discovered Isabella still strapped in her car seat, unresponsive, inside the vehicle. Despite rushing her to Lakeland Regional Health Medical Center, she could not be revived. An autopsy revealed her cause of death as hyperthermia, with her internal body temperature recorded at 104.4 degrees Fahrenheit. Investigations revealed that the temperature inside the vehicle had reached over 143 degrees.
Highest temperature recorded during the study was 143.5. 143 degrees. Yes.
Following the tragedy, both parents underwent drug screenings. The results showed Jasmine tested positive for alcohol and marijuana, while Joel tested positive for alcohol, marijuana, and methamphetamines. These findings led prosecutors to argue that substance abuse contributed to the negligence that caused Isabella's death. Joel's sister testified how good of a father Joel was.
He had a hard time with the loss of my brother, and we all saw it. And I think it affected him more than anybody.
In August 2024, Joel pleaded guilty to aggravated manslaughter of a child. During his sentencing in November 2024, he expressed profound remorse.
And I think it affected him more than anybody.
No matter how events unfold during court and the decisions made will end, the idea of never again walking into my home and seeing my baby leap up and happily yell, "Dad, Dad, Dad," has left me shattered and scarred.
His wife also testified about the bond of the father and daughter.
So I speak on my baby girl's behalf. And I can honestly say that she loved her dad so very much. Her eyes would light up every time she saw him come through the door. And she would show her excitement to be with him.
Despite his emotional plea for leniency, Judge Jalal Harb sentenced Joel to 20 years in prison, emphasizing his repeated failure to notice Isabella in the vehicle, even after returning to retrieve cigarettes from the car.
One of the most impressive facts of this case is that you decided to go back to the vehicle to retrieve your cigarettes. And you didn't notice the child was there. That was after. This is not a question. Are you done talking? So, you failed that child then, or I should say, you continue to fail that child.
Jasmine Rondon, also charged with aggravated manslaughter, pleaded not guilty and is scheduled for a pretrial conference in December 2024. The tragic death of Penny Pizarro left a profound impact on her family and the Albuquerque community. In March 2023, Penny and her father, David Pizarro, were struck by a stolen Chevrolet Suburban driven by 39-year-old John Bearden Jr., who was under the influence of methamphetamine. The crash caused severe injuries to both. Penny tragically succumbed to her injuries 3 weeks later, while David suffered a traumatic brain injury. The collision occurred when Bearden, recklessly speeding through a stop sign, crashed into the Pizarro family's vehicle near San Pedro Drive and Bell Avenue. After the crash, Bearden fled the scene on foot, but authorities quickly apprehended him, hiding in a shed. He faced multiple charges, including vehicular homicide, great bodily harm by vehicle, DWI, leaving the scene of an accident resulting in death or great bodily harm, and unlawful taking of a vehicle. The courtroom was filled with shades of pink, Penny's favorite color, as her family and supporters honored her memory.
Just been asking people for her birthday, for anything that memorializes her, if they could wear pink. Today was obviously a big day for that.
In August 2024, Bearden pleaded guilty to these charges, expressing remorse in court. Tearfully addressing the court, he stated that he was responsible. Despite Bearden's apologies, Judge Fernersbach emphasized the weight of the tragedy.
I just again want to say my condolences, and I think about you guys every day, and I think about Penelope, and I'm so sorry.
I am going to designate count 2 as an SVO. For one, I'll start there.
Bearden's attorney requested that he serve his sentence at a specialized facility in Otero County, citing safety concerns in the general prison population. But the court's decision on this request was not immediately announced.
I do think that there has to be an adequate sentence to acknowledge, that there were chances along the way and those chances were not taken, and to recognize the value of a life that was lost.
But I'm grateful for everything, all the work that the DA has done. I know they put all their heart and soul into it. So I believe it was fair.
On November 14th, 2024, Judge Jennifer Wernersbach sentenced Bearden to 22 years in prison, with an additional 5 years of supervised probation. Due to the classification of his offense as a serious violent crime, Bearden must serve at least 85% of his sentence before becoming eligible for parole. While the sentence was less than the maximum 27 years he could have received, the Pizarro family expressed gratitude for the efforts of prosecutors. "I believe it was fair," one family member remarked. Chad Martin, a father from Athens, Michigan, is facing legal charges after a tragic incident that led to the death of his son. On the morning of August 13th, Martin set out to drop his daughter and son at daycare before heading to work. While he successfully dropped off his daughter, he inadvertently forgot his son in the back seat of his SUV and proceeded to his job, leaving the boy unattended for nearly 9 hours. Temperatures exceeded 80 degrees that day, and the boy succumbed to fatal heat exhaustion. Martin discovered the unresponsive boy in the parking lot of a family fare grocery store in Vicksburg after finishing his work shift. Emergency responders arrived at the scene, but the boy was pronounced dead. An autopsy later confirmed that heat exposure was the cause of death. Following the incident, Martin turned himself in to authorities. He was arraigned on felony charges of leaving a child in a vehicle resulting in death, a crime in Michigan that carries a maximum penalty of 15 years in prison.
Mr. Martin be released to OCC for additional monitoring as this case is progressing.
During the court proceedings, Martin was released on a $5,000 personal recognizance bond, with conditions requiring monitoring as the case progresses. Martin has cooperated fully with law enforcement and expressed profound remorse for the loss of his son. His defense attorney described him as heartbroken and emotionally shattered, emphasizing that the tragedy was an unintentional oversight.
There's nothing the criminal justice system can do to him that's, not going to be worse than the way he already feels about what happened. He's been beside himself since this happened. And he's looking forward to getting back to his family, helping in any way he can going forward. But, again, he's been upset about this and he's been heartbroken about this ever since this happened.
Martin's wife was in courtroom to support him.
She wants him home. She wants him with the family. She wants him to continue working, to continue to support them. So that's very helpful. The fact that she's in his corner, I think, speaks a lot to Mr. Martin, to what he's going through and what he's willing to do to make this right.
Advocacy groups have highlighted the case as a sobering reminder of the dangers of leaving boys and girls unattended in vehicles. Dozens of girls and boys in the United States die each year from heat-related incidents in cars. Michigan has enacted laws to hold individuals accountable for such preventable deaths while raising awareness of the importance of vigilance.
These situations are a tragedy. It is important for us as a society to have a law against it, to hold people responsible to that law, and probably most important to everyone, send a message out there to others that, hey, this is something that we as a society care about, and we want everyone to use all applicable care and caution when dealing with a young person.
Children, obviously, I think, are the most vulnerable demographic in our society, and I think the legislature is doing everything that they believe is right, to hold people responsible for certain situations. But at the same time, there's a guideline range for everybody. There's a statutory max for everybody that's charged with this crime. And I think the individual circumstances are going to have the most to do with, what kind of punishment there is in this case.
Experts stress that these tragedies often occur as unintentional mistakes rather than acts of malice.
Our message to parents is to use extra care. Even if you're watching this thinking, I'm not the type of person that could ever happen to, unfortunately it happens to people, and I think almost by definition this is the kind of thing that happens as an oversight, not because of malicious intent. So be aware of your children, be aware of your surroundings, and even if you think you're the type of person that this could never happen to, you still need to be very careful because you never know.
The case has deeply affected the family and community, serving as a reminder of the responsibility to protect vulnerable lives. Martin has waived his preliminary examination, and the case is proceeding to trial. A trial date has not yet been set. If convicted, Martin could face up to 15 years in prison. The tragic events that led to Oscar Pistorius' trial began on Valentine's Day in 2013, when he shot and killed his girlfriend, Riva Steenkamp, in his Pretoria home. Pistorius claimed he mistook Steenkamp for an intruder, firing through a locked bathroom door. The case, involving one of South Africa's most celebrated athletes, quickly drew global attention. During his trial, the court was presented with dramatic forensic evidence. Colonel Johannes Vermeulen, a seasoned forensic expert, demonstrated how Pistorius, on his stumps, fired the shots and then attempted to break down the locked door with a cricket bat. The defense agreed that Pistorius was on his stumps when he fired, but argued that he later put on his prosthetic legs before trying to break down the door to reach Steenkamp. The condition of the door became a contentious issue in the trial. The defense pointed out discrepancies, noting that new marks appeared on the door after it was taken into police custody.
Whilst the door was in the safekeeping of the forensic department, it somehow happened to get serious marks on it, which did not exist on the 8th of March, 2013.
From this, it appears like that something happened to the door after the 8th of March, which I would not be able to comment about.
136 to 200 South African Police Services admitted that evidence may have been mishandled, raising serious questions about the integrity of the investigation. This revelation led to broader concerns about the reliability of South Africa's forensic laboratories and law enforcement practices. In 2014, Pistorius was initially convicted of culpable homicide and sentenced to 5 years in prison. However, an appeal court later overturned this verdict, finding him guilty of murder. The court ruled that Pistorius acted recklessly, fully aware of the risks his actions posed. In 2017, he was sentenced to 13 years in prison for Steenkamp's murder. After serving nearly 9 years of his sentence, Pistorius was granted parole in January 2024. His release stirred significant public debate. Pistorius has since been residing with his uncle in Pretoria and engaging in volunteer work as part of his reintegration into society. Reports indicate he is in a relationship with 33-year-old business management consultant Rita Grayling. This has drawn sharp criticism from Steenkamp's family, particularly her mother, June Steenkamp, who expressed concerns about his temper and questioned whether he has shown genuine remorse. As part of his parole conditions, Pistorius remains under strict supervision until his sentence officially expires in December 2029. He is required to attend therapy sessions addressing anger management and issues related to gender-based violence. Despite his release, opinions remain divided, with many questioning whether his punishment and rehabilitation are sufficient to account for the gravity of his actions. Patrick Evans, a former Jabal Circuit executive, was convicted for the 2008 murders of his estranged wife, Elizabeth Evans, and her boyfriend, Gerald Taylor, at Elizabeth's Gulfport townhouse. The tragic events occurred just before Christmas, and chilling 911 audio recorded during the incident captured the fatal shootings.
Sit on the bed, Jerry. I'll sit down. Let's put the... Hey.
Investigators concluded that Evans, armed with a gun, was responsible for the murders. In 2011, a jury found Evans guilty of first-degree murder and recommended the death penalty. His mother made an emotional plea during sentencing, asking the jury to spare her son's life.
I beg you not to do that. If there's anything else, if I could say, I beg.
However, the court sentenced Evans to death unexpectedly in 2015. The Florida Supreme Court overturned Evans' conviction and death sentence, citing errors during the trial and ordering a retrial. The retrial, held in October 2017, once again resulted in a guilty verdict on 2 counts of first-degree murder. This time, however, the jury opted for life in prison without the possibility of parole instead of the death penalty. Evans appealed the life sentences, but in June 2020, the Florida 2nd District Court of Appeal denied his request, upholding the sentence. He remains incarcerated, serving his life sentences without the possibility of parole. Daniel Negrit and Fatima Avila, a young couple, face 2 first-degree murder charges in a chilling case of revenge and deception. Prosecutors allege the couple meticulously planned and executed the murders, attempting to frame one of the victims for another killing. The case has intensified as the state announced its intent to seek the death penalty for both. The sequence of events began on July 18th, 2022, when Fatima Avila, described as the mastermind, allegedly conspired with her boyfriend, Daniel Negrit, to murder Erica Negrit Aviles, Daniel's cousin's wife. Believing Erica was having an affair with a co-worker, the couple planned the attack. Erica was shot outside her home in Dover, Florida, while her husband, Cornelio Negrete Jr., was also shot but survived his injuries. Following Erica's murder, the couple allegedly sought to divert suspicion by framing Fatima's ex-boyfriend, Antonio Cuellar Enriquez. On July 26, 2022, Enriquez was found dead at the Baker Creek boat ramp in Thonotosasa. Investigators determined that Daniel shot Enriquez, staging the scene to look like a suicide in an attempt to mislead authorities.
She stated to the identifiable witness that who better take the fall than my ex.
In court, Daniel was seen whispering, "I love you" to Fatima during the proceedings. However, the courtroom atmosphere turned grim as prosecutors announced their intention to pursue the death penalty for both defendants, citing the calculated and premeditated nature of their alleged crimes. While Daniel and Fatima have court-appointed attorneys, Cornelio Negrete Jr., who was also arrested for his alleged involvement, is still seeking legal representation.
We're moving to withdraw the conflict on Cornelio Negrete. We're keeping Daniel Negrete.
Unlike Daniel and Fatima, Cornelio is not currently facing the death penalty. Adding to the complexity of the case, Fatima, now 21, allegedly attempted to solicit fellow inmates at the Falkenberg Road Jail to murder a key witness in her case. She reportedly offered payment to multiple inmates for carrying out the crime, leading to additional charges of solicitation to commit murder. Both Daniel and Fatima remain in custody, awaiting trial on these severe charges. If convicted, they could face the ultimate punishment, death row. The third defendant, Cornelio, awaits legal proceedings but is not subject to the death penalty at this time. The court convened to address the sentencing of William Rubert, who faced charges of resisting and obstructing, a felony carrying a maximum sentence of 2 years. This case followed a delay in sentencing due to violations of probation and additional legal complications. The defense attorney spoke on behalf of Mr. Rubert, describing him as cooperative and pleasant to work with. He acknowledged the challenges of defending someone with a history of legal issues, but emphasized Mr. Rubert's efforts to turn his life around. During his probation period, Mr. Rubert struggled with substance abuse, parenting, and maintaining a relationship with a partner who also faced addiction issues. To escape these difficulties, Mr. Rubert made the decision to leave Michigan, which, while legally problematic, may have saved his life. The attorney shared a letter from Mr. Rubert's mother, asserting that staying in Michigan could have had fatal consequences for him. The defense also noted that Mr. Rubert successfully completed probation in Florida, a positive step that should be acknowledged by the court.
Of course, for Mr. Rubert, Judge, what I will say on his behalf is that he's been a very pleasant person to work with. I know that we always have an uphill battle from the defense side when there's such a long absconding period. I'm sure the court wants to know what Mr. Rubert was doing.
Other than committing a felony in Florida.
Right. So part of what I wanted to bring up is that, right, was that he did have that probation sentence out of Florida. It does appear to me that he successfully completed it. I don't at least see anything to the contrary. Normally there is a pretty clear demarcation that, someone was unsuccessful or terminated unsuccessfully, et cetera, et cetera. I don't see that, so I have to assume that he's completed successfully. I do think that's a positive, not the new criminal behavior, but the fact that he completed community supervision is and should be considered a positive by this court. What I would also let the court know, and I think the PSI alludes to this a little bit, is that Mr. Rubert was obviously struggling at the time that he was placed on this original probation sentence, struggling with both drugs and alcohol, struggling with figuring out how to parent a child, figuring out how to be a partner to another person, another human being that's also struggling with drugs and alcohol. Unfortunately, Mr. Rupert made a decision to leave Michigan. Unfortunate for him legally. I think very fortunate for him personally, because as he and I have talked about, and his mother has written a letter to me at this point. Everyone is very convinced that if he would have stayed here, he would be dead. And so I'm thankful that he is not dead and that he is alive and before us and here to be sentenced. Judge, he did lose his partner December 23, and I think to her addiction. And I think if anything, that was a real wake up call. I know that's sort of a cliche thing to say, but for him, I think it's true that opened his eyes and affirmed his path going forward. And I hope he stays on this path. I think that he's a very nice guy. I think that he has a lot of positive things going for him in light of some of the negative things that are in that PSI. I think this court should sentence him as though the delay never occurred. So I think the court has to wrestle with, well, what would the court have sentenced him to had we not gone through all this time? And so I guess that's my question for the court is what is fair and under these circumstances. I would posit to the court that 60 to 90 days would have potentially been a fair resolution at the start. And so that's what we would ask for now, understanding the recommendation. But nonetheless, Mr. Rupert is he's here and he's accountable for his actions. He knows that he's made mistakes and he wants to move forward and do better. Thank you.
The attorney highlighted the loss of Mr. Rupert's partner to addiction, an event that profoundly impacted him and served as a turning point in his life. The attorney urged the court to sentence him as if the delay in proceedings had not occurred, proposing a resolution of 60 to 90 days as fair and appropriate. He concluded by emphasizing that Mr. Rupert fully accepts responsibility for his past mistakes and is committed to moving forward in a better direction.
Oh, yes, thank you, Your Honor. The defendant is 35 years old. He has no prior felonies and 5 misdemeanors. He was given a second chance initially on this case by being offered a delay. He chose not to take that second chance and instead made the decision to leave his probationary terms, commit another felony, and did not return on his own. He also was granted another gift by not being charged with absconding, which would have been warranted in this case. I ask that the court follow the PSI recommendations for 6 months.
The prosecution, however, detailed Mr. Rupert's history, which included 5 prior misdemeanors and a violation of probation terms. The prosecution emphasized that Mr. Rupert had absconded to Florida, where he committed another crime. Although the prosecution noted that additional charges for absconding could have been filed, they recommended a 6-month jail sentence in line with the pre-sentence report.
Thank you, Mr. Rupert. If you want to please stand for the court sentence. This is I know your attorney has given, I don't take them to be excuses at all, and they weren't offered for as such, but as explanations for a period when you were making bad decisions, and he's, set forth some explanatory reasons for what was going on in your life for that, which it's just unfortunate too, because, the police are called out to your residence for what would have been a misdemeanor case. So let's back up to that night. There's a domestic incident, police go out there, and then you think you're in Shawshank Redemption or something. You're running through the woods and they're after you with a dog, and now you got a felony case for an R&O. And then you get a delay of sentence, or you don't go to jail for it, and you get a chance to have the felony go away. And then you take off. You tell your probation officer, gee, being on supervision sucks. Well, yeah, I know that. But nobody just grabbed you at random out of society and said, guess what? You get to be under the supervision of the Department of Corrections probation parole agent. You did that. And you decided that wasn't a plan that you liked, so then you flee to Florida. And then you get in more trouble down there. And then you don't, I don't know why. I mean, now it's 4 years later and you're back dealing with this case, which again, started as a misdemeanor case. And you've just made it grow and grow and grow. Where we have somebody on a delay and they pretty much thumb their nose to supervision, take off, go to another state and commit crimes, or at least a crime. The prosecutor's right, they could have charged you with absconding a felony, which is a 4-year felony, even more than what you have right now. And they have not done that. And there's good reasons not to do that under these circumstances. So I'm not faulting that at all. But I think all that to be said that the recommendation from the Department of Corrections is I think a fair one, and it's measured under the circumstances that's what's going to happen for you here. I hope you have turned some things around and that this is a case that shouldn't have been a felony to begin with. So I certainly hope we don't see you back in felony court here. But again, that's going to be up to you. So I will sentence you, the fines and costs will be as assessed in the previous hearing, the amount of any unpaid balance, and I'll order that you serve 6 months in the Sheboygan County Jail, credit for 51 days served. That is within the advisory guidelines, although they are an intermediate sanction. There's reasonable grounds for incarceration in that Mr. Rupert absconded from supervision.
The judge expressed frustration that what began as a misdemeanor had escalated into a more serious case due to Mr. Rupert's decisions. While acknowledging the difficult circumstances in Mr. Rupert's life at the time, the judge underscored the importance of taking responsibility for one's actions. The court sentenced Mr. Rupert to 6 months in jail, with credit for 51 days already served. The judge also addressed Mr. Rupert's unpaid fines, providing a plan to resolve them after his release, and encouraging him to use this experience to avoid future legal trouble. The legal proceedings involved Judge Simpson presiding over the case of Mr. Gu, who was charged with resisting and obstructing a police officer. This offense, considered a high court misdemeanor or felony, carries a maximum penalty of 2 years in prison and a $2,000 fine, plus court costs. Mr. Gu chose to represent himself, prompting the judge to explain the risks of self-representation. Judge Simpson emphasized that Mr. Gu would be held to the same standards as a trained attorney, including knowledge of the law and adherence to courtroom procedures. The judge reminded him that he could request a court-appointed attorney at any time if he wished.
Mr. Gu, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor and or felony, punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself. In this, you have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If, for whatever reason, during any point in this proceeding, you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you.
The case progressed to procedural matters, with Mr. Gu requesting a preliminary examination to review the evidence against him.
Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or prelim.
You wish to have a preliminary examination?
Preliminary examination, yes, sir.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals of the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern of the court. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping that we can sort of reconcile both of those things as whether or not discovery is complete, the defendant's prepared to move forward, and if he ever has filed a notice of hearing to go along with the motion that I received in this case on 11/22.
The prosecutor raised concerns about unresolved issues related to discovery. Mr. Gu had filed a writ of mandamus with the Michigan Court of Appeals, alleging that the prosecution failed to provide all necessary evidence, specifically exculpatory material. The prosecutor countered that all required discovery materials had been provided, and noted that Mr. Gu's filings included claims previously addressed and denied by the court. Additionally, the prosecutor mentioned that Mr. Gu had filed a motion without attaching a required notice of hearing, which needed to be resolved. When asked for clarification, Mr. Gu expressed dissatisfaction with the discovery, stating it lacked evidence that could prove his innocence.
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my, what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong, as far as anything that they've submitted. So if it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying. Because what you just said regarding discovery didn't make any sense.
He acknowledged that his earlier statements might have been unclear. After considering both sides, Judge Simpson concluded that discovery was complete and decided that any pending motions would be addressed during the preliminary examination.
As it regards the motion, we will hear the motion the motion will be heard on date of exam.
Thank you, Your Honor.
With it at that point in time. So the people would have their witnesses available on the second.
We can try for the second, Your Honor.
Preliminary examination in person, January 2nd.
The court scheduled the preliminary examination and motion hearing for January 2025. Both parties were instructed to prepare for the in-person hearing. The judge ensured fairness while emphasizing the importance of following procedural requirements. The hearing would address outstanding issues, including the motions and the prosecution's evidence against Mr. Gu. The defendant's legal issues began after a minor traffic incident in Harris County, Texas. The complainant, while backing his vehicle, accidentally tapped the defendant's car. Believing no damage had occurred, the complainant continued driving and turned onto a cross street. However, the defendant began to follow him, eventually stopping behind the complainant's vehicle in a McDonald's parking lot. The complainant, unsure of the situation, parked and got out of his car to ask the defendant if everything was okay. The defendant approached the complainant's vehicle and became verbally aggressive, accusing him of hitting his car. The complainant, still sitting in the driver's seat, tried to explain, but the defendant was standing too close, preventing him from exiting the vehicle. The complainant got visibly injured. The defendant continued to yell at the complainant, demanding he get out of the car, but the complainant stayed inside.
In the second case before that we arrived at a McDonald's parking lot at 13532 Beechnut Street in Harris County, Texas, where he made contact with the defendant and a complainant who were near their vehicles. The complainant and the defendant do not know each other. The complainant stated that when he was driving on the public roadway, he accidentally backed his vehicle into the defendant's front bumper. The complainant believed that he did not strike the defendant's vehicle at the time of the impact and drove away onto the cross street. The defendant began to follow him. The complainant parked his vehicle in the McDonald's parking lot and observed the defendant's vehicle stop behind his car. The defendant approached the driver's door of the complainant's vehicle. The complainant opened his driver door and asked the defendant, "Hey bro, are we good?" The defendant became verbally aggressive towards the complainant, yelling at him and telling him that he hit his car. The complainant remained sitting down in his driver's seat. The defendant was so close to the complainant that the complainant could not walk out of the vehicle. The defendant with his left fist struck the complainant on the right side of his face, causing pain. Defendant repeatedly told the complainant to get out of the car. The complainant remained in the vehicle while the defendant continued to yell at him, standing outside of the driver's side of the vehicle. The complainant had a purple discoloration mark with red swelling on his right cheek, consistent with that of a physical assault. The white area of the complainant's right eye was pink compared to his left eye. A vehicle inventory of the defendant.
When officers searched the defendant's car, they found 2 plastic bags containing marijuana.
A vehicle inventory of the defendant's vehicle revealed a clear plastic bag containing 2 separate plastic bags of marijuana, total weight 83 grams, 2.9 ounces.
Mr. Wyckoff, I'm going to find that there's probable cause to go forward with the case. I'm going to tell you that all you really had to do was call the cops when that dude took off, and then they probably would have had that dude arrested. But now, because you took matters into your own hands, you and I are not going to have a good time. I am now sending you for a drug test. I want to know what, if anything, is in your system, and you must come right back to court. Do you understand?
The judge reviewed the case and decided there was enough probable cause to move forward with the charges. The judge commented that the situation could have been avoided if the complainant had simply called the police when the incident occurred. Instead, the defendant escalated the situation by following the complainant and confronting him.
Do you have a Texas driver license? Yes, sir. You run his license, please. Do you have valid liability insurance in your name? Yes, sir. I want proof before you leave here today to see whether I'm going to allow you to drive or not. Number one. Number two, as a condition of your bond, you are not allowed to use dope or any kind of dope whatsoever or alcohol. If I find that you're using anything, I'm going to put you in jail and I'm going to make your bond sky high. Do you understand? Sir.
This license is eligible, Judge.
Thank you. I'm ordering you also as a condition of your bond not to be in possession of any weapons and not to have any contact with the complaining witness in this case. Rachel, I'd like to send him down right now for a drug test. I'm gonna have you sign a receipt and then I'm gonna hand you off to take a drug test and then you must come right back. Do you understand?
The judge then addressed the defendant's bond conditions, instructing him to take a drug test to check for substances in his system. As part of his bond, the defendant was told he was prohibited from using drugs or alcohol. If he tested positive for any substances, his bond would be revoked, and he would face a higher bond amount. The judge also asked about the defendant's driver's license and insurance status, requiring proof of valid insurance before allowing him to drive.
Okay. Mr. Wyckoff tested positive for cocaine. He also tested positive for, what else was it? Mr. Wyckoff, I'm going to tell you now, I'm not putting up with it. I'm not going to let you do this while you're on my watch. So, sorry, it's okay. It stops now. And if you don't, we have one place for it. You understand? You will be drug tested like crazy. I'm going to bring you here 2 times a week so that you prove to me that you're not consuming any kind of cocaine, alcohol, or any dope whatsoever. And the first time you test positive, you will go to jail. I know that you're going to test positive now for the next 3 days, maybe 4. But after that time, if you have continued to test positive for cocaine, then you will go to jail. As far as the weed is concerned, I will give you a 35 to 40-day window. And after that, if you test positive, that tells you that you've continued to use, and likewise, you will go to jail. And I'm going to tell you now, no more PR bonds. Do you understand? I don't care if you're mad at me. I don't care if you're, look.
I'm not going to make it 2 times a week.
Well, then
drugs has not worked and everything. No, that's not going to happen.
Yes, it is. All right. I will give you the opportunity. If you don't, then that's fine. You don't have to come. You know what's going to happen, and that's it.
Judge, I would ask the court to consider just either once a week or every 2 weeks.
No, because he can still use and he can evade capture with it. And, you know, I don't want you to continue to use cocaine, and that's it. And I'm not going to trust you.
I can't even use cocaine. I have asthma. That stuff will break my lungs.
You tested positive for it.
I can't use it.
Well, okay. Prove it.
I have asthma. It's in the system.
Prove it. I'm not going to take your word for it. So that's already giving you a lawyer, Mr. Wyckoff. You know what's expected of you. All you have to do, I'm not asking you to show up here. I'm asking you to just go take a test, and then you can take
Like
off.
I said, I work. I'm not finna take 2 times out a week to go take a test. No.
That is the bond condition.
All right. I could have paid my own bond for that.
It's still a condition I'm going to put on you, whether you paid your own bond or not. If you don't like it, don't pick up a new case.
The defendant was reminded that, as part of the bond, he would need to submit to drug tests twice a week. The judge explained that if the defendant failed to comply with the drug testing or tested positive for any illegal substances, he would be sent to jail. The defendant objected to the frequency of the drug tests, asking for a reduction to once a week or every 2 weeks. However, the judge firmly maintained the twice-a-week requirement, explaining that it was necessary to ensure the defendant's compliance with the court's orders. The judge emphasized that if the defendant continued to test positive for substances, further legal actions would be taken, and he would no longer be eligible for a PR bond. The defendant was told to begin testing, and if he tested positive, he would be brought back to court to address the situation. The hearing concluded with a final warning. The defendant had the chance to correct his behavior, but any further violations would lead to severe consequences. The judge wished the defendant good luck and reminded him that his future actions would determine the outcome of the case. A man, already out on bond for an assault case, found himself in legal trouble once again. The new incident took place in Harris County, Texas, where the defendant was allegedly involved in another confrontation. This time, he was accused of pulling a woman's hair during an argument while they were driving. According to the woman, the defendant tried to grab her purse, which contained a USB drive with fraudulent material. As tensions rose, the argument escalated, and she ended up feeling pain from the hair pulling and a scrape on her hand.
Complainant and the defendant dating relationship. On 11/27/24, officers were dispatched to an assault in progress in Harris County, Texas. Officer met with other officers who had already detained the defendant. The officer spoke to the complaining witness, who stated the defendant pulled her hair at the house and that she felt pain. She stated that they had been driving down Westheimer and the defendant attempted to take her purse that had a flash drive that had fraudulent scam material on it. Complaining witness said the defendant was trying to scam San Jose Gas Oil, and the information was on the USB drive. Complainant stated that they started to fight, and she scraped her hand on the purse and felt pain. Complaining witness also stated no threats were made, and the suspect did not put his hands on her. Defendant stated they were arguing in the car, and the complaining witness slapped him twice and scratched him. Defendant stated he felt pain. The witness stated she worked security and she saw the traffic was backed up, so she drove up and saw the complaining witness and the defendant in a stopped car in the street. She said she saw the complainant and the defendant fighting. Complaining witness was trying to exit the vehicle, and that's when the defendant pulled her hair. Witness stated the complainant exited and ran across the street and called 911. Officers observed blood on passenger window where complaining witness was sitting. Officers also observed complaining witness to have injuries to both hands.
The defendant, however, claimed that the woman slapped and scratched him first, and he was simply trying to prevent her from exiting the moving vehicle. A witness who was nearby saw the two of them fighting inside the car. She observed the woman trying to leave, and it seemed like the defendant was pulling her back into the vehicle. When the woman finally exited, she ran across the street to call 911. Police arrived to find her with visible injuries, and they quickly detained the defendant. This new incident violated the defendant's bond from a previous assault case, and it raised serious legal concerns. The court had to review the evidence to determine if there was probable cause. Despite the defense claiming that the defendant was trying to stop the woman from hurting herself, the witness's account contradicted that claim, suggesting that the defendant's actions were unprovoked.
It's alleged here that you have assaulted this person, and they have now provided me with enough evidence that I'm going to find probable cause that that it occurred. Joe?
Your Honor, the only thing I can say is the client has vigorous defenses. Obviously, that's not the appropriate point to point out. But I don't know, was the complaining witness out on probation at this time or because she herself was under
Well,
some legal.
all I know is that
Very
is
serious.
it 2 times that he pulled her hair, or was it just 1 time? It sounded like it was.
Just a one-time, Judge.
He was trying to prevent her from, she was gonna go out of the moving vehicle, was what his position was. He was trying to keep her from getting hurt, from going out of the moving vehicle.
I didn't hear anything about that.
Because I believe what happened is she called and reported this afterwards. They left the scene and then she called, phoned it in and reported it after.
So is she trying to jump out of a moving car and he's pulling her hair to keep her in? Well, but then the witness sees them outside of the car arguing and then he pulls her hair outside of the car.
I heard that. I did hear that,
So
Your
the
Honor.
witness saw the defendant and the complaining witness inside the vehicle fighting. The witness tried to get the complaining witness out of the motor vehicle, and then the defendant
Picked up a new
pulled her back
case.
by her hair.
Are we supposed to be happy you're on bond for an assault and you pick up a new assault?
Yo no daría daño nunca a la persona que
Well,
quiero.
now is, I mean,
I would never hurt somebody that I'm with. Por favor, me quiero que diga su señoría. Ella es mi novia. Ella ahora mismo está en la prisión. She's my girlfriend. She's right now in jail. He has. Porque ella está enviciada en la droga. She has problems. She's drug addicted to drugs. Yo quiero que ella. I want her to be hospitalized.
The only reason that was relevant, Your Honor, if I could help him out, is that he did tell me beforehand to help the court and the system, is that she has been his girlfriend for many years, and that he has 1 child he supports along with his mother, who's here today, and he works as a driver, and he does support them all. But she does have this problem with drugs and has this pending case. He himself suffers from depression and diabetes, but he does manage to work in order to support them all. If these are just things that maybe the court could consider, because it would be a real hardship for them to lose the income. Now, he would agree to any kind of additional controls in terms of staying away from her, but maybe 200 feet away or things like that. Because she's not living with them. The child is not hers. It's from a previous relationship that he supports. But they're actually 2. One is 7 years old. One is 7 years old, and the other one is 3 years old. And so we're talking some very fairly young children that's in his custody. Now, his mother has been helping maintain him. She's back there on the second.
The complaining witness is currently in jail.
In the courtroom, the judge explained that picking up another case while on bond for a previous one would not be taken lightly. The defendant was told that further actions like this could lead to even stricter consequences. The defendant's personal struggles, including depression and diabetes, were mentioned by his lawyer, along with the fact that his girlfriend had a history of drug addiction. However, the judge emphasized that such personal difficulties could not justify violent behavior.
In my community, you've now picked up a new case. I'm not going to let you go. You picked up a new assault. Doesn't matter who it is. Doesn't matter where it is. We ask you to behave yourself. And when you pick up a new case, that's not a good thing. And if I let you go, that is telling you it is okay to do what you're doing. And it's not. There has to be consequence to action so that you understand we mean business. If this person is like that, then you know, or you should know, not to associate yourself with this type of person. Do you understand?
But please, my family depends on me.
Then this is what you think of beforehand. You don't think about this after the fact.
But I didn't do anything. I wanted to help her.
I'm not going to talk to you about the case. I'm not going to know. Now, I will tell you this, that I had already revoked your bonds and I was going to set them both at 10,002, but I won't do that. I'll entertain a lower bond with you, Joe. I mean, what do you think is appropriate? I want you to understand that I'm going to take you in because I want you to understand that public safety is my number one concern. That's it. As a courtesy for your lawyer, and because of what you're saying, I will not set it as high as I was going to, and I will entertain a lower bond. But you picked up a new assault.
Your Honor, would you consider $1,500?
What do you think?
Judge, I'm just gonna argue for a general $5,000 bond. This individual was told obviously not to pick up any new cases and he took the exact same kind of case while on bond previously.
All right, so what I'm gonna do is I'll split the puppy, okay? And on the new case, he's at 5,000 now on the old case. I'm gonna revoke that PR bond. I'm gonna set that one at 5,001. And then on the new case, I'll do it 3,501 as opposed to 10,002 on both of them. And that is, Joe, you know, I hope that you now understand that we mean business. And no matter what the excuse, no matter who you're with, you pick up a new case, there are consequences.
Yo le prometo que usted no me va a ver más nunca. Problema, yo nada.
Promise I won't cause you any more problems. You won't see me for something like this again.
I hope you show back up to court.
Es serio, ¿no?
Stay in contact with your lawyer.
Sí, claro.
Of course.
And from now on, as a part of your,
Le pido una disculpa porque
don't.
Porque yo el día 4 no tenía mi corte.
Jacques, no habla. I want you to listen. I don't want you to have contact with the complaining witness in this case. I do not want you to be in possession of any weapons. You are also not to have contact with the complaining witness in the first assault case. If you pick up a third case, I am telling you now, I will go absolutely bonkers on your bond. Do you understand? The only reason I'm making the bond as low as it is now is because of Joe. Otherwise, your bond would be at 10,002. But as a courtesy, but I will have absolutely no qualms whatsoever if you pick up a third case.
To protect the victim, the court issued an emergency protective order, preventing the defendant from contacting her in any way, including approaching her home or workplace. The defendant was warned that if he violated this order, more severe actions could be taken. As a final gesture, the judge lowered the defendant's bond, but made it clear that any further incidents would lead to harsher consequences. The defendant was told to stay in touch with his lawyer and comply with the bond conditions, which included avoiding alcohol, drugs, and weapons. In the end, the judge's ruling balanced understanding of the defendant's family obligations with a firm commitment to community safety. The message was clear: the law would not tolerate any further violence, and the defendant needed to take responsibility for his actions moving forward. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.